It's Sunday morning, and we are protecting military families on 104.5 WOKV, Jacksonville's News and Talk, with Chris Brochu, owner of Brochu Law and the Military Second Opinion. Chris, before we go any farther, good morning. How are you? But we don't want to bury the lead here. Explain what that second opinion is, because that's your thing, man.
Good morning, Casey. The weather here in Florida is great, starting to heat up a little bit, but phenomenal. The second opinion is similar to anything else that you'd get medically or any other area. You bring your car in to get it fixed and somebody's charging you too much. In the second opinion for purposes of my firm, it's basically if you're a military family and you believe that you may have a legal right or a legal benefit available, right, a benefit related to your military service or a benefit that's available to your family, and you don't think that your denial was proper, you think that you're leaving benefits on the table, maybe even just want to explore what your benefits are, feel free to give us a call. The consultation's free. Essentially, the only way that we will end up working together is if we sign a fee agreement. At that point in time, everything that we do is on a contingency fee basis, so there's no fee unless we win. We never charge service members, veterans, or military families up front. And again, no fee unless we win. We advance all costs on behalf of military families.
So that's what that is. We'll talk more about it as we go along. But if you need his help, Case, C-A-S-E, at brochulaw.com, B-R-O-C-H-U law.com. Or you can give him a call at 904-201-1771. We are on 104.5 WOKV this morning. And Chris, today we are talking all about TSGLI. Just on the surface, let's go right into it. What is TSGLI?
So most people would hear this topic and skip to their next station, but I promise you, if you served in Iraq or Afghanistan or you know somebody that did, you're going to want to listen up. It's one of the claims that you more than likely were paying for, whether you knew it or not, and it's essentially the traumatic injury rider of service members group life insurance. So anybody that's served in the military since 2001, October 7, 2001, would have had service members group life insurance available to them. It's offered for all service members. When service members leave the military, you're eligible to transfer that to VGLI, Veterans Group Life Insurance. But TSGLI is only applicable to service members group life insurance. It does not transfer to Veterans Group Life Insurance. But the important thing to know is it is the traumatic injury rider, or the civilian equivalent would be a mix between an accidental death and dismemberment policy and a long-term, short-term disability policy.
In that, there's a lot obviously to go into that, but let's just start what qualifies, like what kind of injuries? Does it have to be certain things? Are some things not covered, or is it just overall, if you're hurt, you're covered?
Great questions. I wasn't around when Congress was talking behind closed doors about the needs, but obviously now that we know the significance of our wars in Afghanistan and Iraq and the service members that came home, we understand that TSGLI is crucial. And TSGLI was to sort of bridge the gap between service members that suffered from a traumatic event and when they had other resources or benefits available to them, or they were able to work again, or any lapse in payments. That was sort of going to bridge that gap, and that's why it was enacted in October 7th. It was enacted in 2005, but it's retroactive to October 7th, 2001. So even if you were injured in late 2000, December of 2001 or 2002, 2003, 2004, anytime in 2005 before December, even if you weren't paying premiums, it's retroactive to October 7th, 2001. So that's why, again, it's not like the military is trying to hide the ball here, but it was enacted years after we had just tons and tons of service members returning with significant traumatic injuries.
Absolutely. And when you say returning, obviously with the injuries, does that have to be did you have to get the injury while you were in combat, or could it have happened at any point in time while you were in the military?
Great Great question again. Primarily when TSGL came out, it was for service members that had been injured on duty, right? You were injured in a training accident. You were injured during combat. Over time, like all great consumer statutes, they've evolved to provide further protections. So this one, even though it's not, technically a consumer statute because it's only available to service members, it still is protecting our military and their families. And I think what happened is that Congress recognized the need for on-duty and off-duty injuries. And basically what happened is originally it was only for on-duty injuries. And we're going to get into what some of those injuries are and what examples or the common ones that I see on duty and off duty a bit later when we get into the traumatic event portion. But primarily it was because we had service members returning home that had lost limbs, were paralyzed, had 15 days inpatient hospitalization, sensory loss, burns, traumatic brain injuries, coma, inability to perform activities of daily living. Those are all qualifying losses. Those are things that Congress wanted to protect service members and their families that had suffered those injuries.
Absolutely. 104.5 WOKV, Jacksonville's news and talk, protecting military families with Chris Brochu. Also a video version of the show on Chris's website, thanks to our guy Justin at Nova Productions, his website, brochulaw.com. Chris, when we talk about TSGLI, is there statute of limitations, right? That's something that people know and understand. If this happened to you, obviously, when this became enacted way back in 2001, 2003, it's been a long time. So can those people still, if they have injuries and haven't really pursued it, can they still kind of go at that and see what they can get?
Statute of limitation, for listeners that have never heard of that legal phrase before, it essentially just means that if you don't bring a claim within a specific amount of time, and usually it's based either on state or federal law, if you don't bring your claim, your lawsuit, whatever you want to call it, within a specific time period, it could be time barred forever. So an example that most listeners, especially the ones in Florida, would understand, right? We see the billboards, we hear the radio ads of automobile accidents. Well, the state of Florida has a 4-year statute of limitation for auto accidents.
Interesting. Meaning
if you were in an accident today, within 4 years from today, you'd have to file a lawsuit or you'd never be able to bring one, based off of just those basic facts. Obviously, they're individual ones. TSGLI, on the other hand, interestingly enough, has no statute of limitation. So you could have been injured in 2002 and find out about TSGLI listening to this show or watching this program, if you're watching the podcast, and say, hey, I think I'm qualified. And we could work up a claim for you literally now, and there's no way that it would be time barred based off of the current regulations, codes, federal statute.
How often do you have clients that need your help in this exact situation where they're like, hey, it's been a long time, is there anything you can do? Is that something you get often?
Sure. And most of it, all roads lead home, right? Most of the claims that I first start sort of triaging have to do with what information is available or what information a military family knows best. And when I say all roads lead home, it's usually VA disability, right? Usually military families have heard of, know somebody that's had a impairment rating, right? A service-connected injury. And so the process usually starts with, I'd like to investigate if I'm service-connected or if I can get an impairment rating with the VA. And basically from there, we look at, okay, we've had an opportunity to review the entire medical record, and does this individual that's calling have other claims? And TSGLI would be one of them. We'll get into a conversation with the veteran, service member, or their family about, okay, you did serve between this October 7th, 2001 time period to present day. But primarily, first thing we look at is when did you serve, right? Were you active duty, reservist, National Guard, one-day muster duty after October 7th, 01? That's the start of the conversation. If you answer yes to that question, you're automatically in this review of did you have an injury or a traumatic event, right? Because you need both, but is there something that you can recall that would potentially lead to TSGLI? And for those families that do have or have served right after October 7th, 2001 to present day, you may be eligible for up to $100,000 per traumatic event if you meet the statute's criteria.
Absolutely. You just said something that is interesting, and I don't know if you can even explain it anymore, but I'm going to ask you to try. You said you need both a traumatic event and an injury.
Right.
Do you have times where you don't see both of those things? Like what qualifies as like a traumatic event?
So this is one of the main reasons why I'm so glad that we get to talk about TSGLI for an entire hour. We may even expand this into a part 2 if we can't get through it all. It's comprehensive. The law is overwhelming when you read the statute and what qualifies, but the 3 elements that you'd want to take a look at was the individual, the service member paying for SGLI premiums. Were they paying for service member group life insurance? Now, here's where the examination comes in and the consultation. If I get a call from a service member that served before December of 05, right, sometime between October 7th, 01 and December 05, they'd be like, that's a trick question because there's no way we could pay premiums for something that didn't exist, right? Mm-hmm. So technically, basically what happens is we would look at that and what the law says is that, okay, if you served in this time period, there was no way for you to pay premiums because the law hadn't been enacted, so you're automatically qualified. Okay. So they would check that box. After December 05, what we have is, were you paying for service member group life insurance premiums? And if you look back at your LES statement, your leave and earnings statement, it will show after that time period $29 coming out of your leave and earnings statement. 28 of those dollars go towards service member group life insurance, and $1 would go towards that traumatic injury insurance. So that's the first step. And then there's even an additional one, right? Let's say a service member was not paying for SGLI premiums, but they were deployed to a combat zone. Department of Defense was covering their premium, so they would be covered as well. So a lot of times, don't count yourself out. I mean, I've had clients that I've gotten paid under TSGLI that during the initial call they said, nope, there's no way that my family qualifies. There's no way. So just it's a case by case basis. It's one of those things that we have to really kind of take a fine tooth comb and talk through. But so if we get through the first hurdle, which is usually, again, knock on wood, everybody that I've encountered, which is, that I've had discussions with, hundreds of service members and military families have been paying SGLI premiums. The second prong is traumatic event. So to your question, traumatic event, qualifying loss, traumatic event, and we're going to break both of these down even further, but traumatic event is that on-duty or off-duty injury caused by a physical force. So it would not, unfortunately at this time, the only non-physical force that is covered under TSGLI as a qualifying loss is a traumatic brain injury. So PTSD would not be covered. But here's an exception. If PTSD led to a 15-day or greater inpatient hospitalization, that service member may now have a claim for $25,000. But traumatic event, on-duty or off-duty injury, and here's the causal link. Here's how we connect it to the qualifying loss. The traumatic event, right? Let's say you were injured in a training accident, you tore your Achilles.
Okay.
Within 2 years of that training accident, right? You're climbing over a wall, you're rappelling, down a wall, you're hurdling over something. Within 2 years of that torn Achilles, if you had surgery, now we get into, was there a qualifying loss? And in this example, we would say, okay, traumatic event, training accident, right? This person is doing something where they were physically injured by some force, external force against them. And within 2 years, if that individual has a surgery, we would look at, in this particular circumstance, did they spend 15 days in the hospital? That would be the first one. And then the second question is, were they unable to perform and required assistance for at least 2 of 6 activities of daily living for a period of 30 days? And that's when we'll break down the qualifying losses too, but that's how we would connect the dots. So paying premiums for SGLI, which automatically enrolls you into TSGLI. There's no way to opt out. Traumatic event, within 2 years of the traumatic event, on duty or off duty, you have a qualifying loss. So when we say traumatic event, I want you to think accident, traumatic accident. When we say qualifying loss, I want you to think traumatic injury. Hopefully that breaks it down a little bit further.
Yeah. It's funny when you say that, because I never would have considered like a training accident as like, that's not where my mind went. And I think that's where most people's minds don't go. They go to like something that would have happened in combat or something like that. How often are these cases that you get, at least, training accidents or non-combat war situations?
It could, a lot of them, because it could be something that, again, to your point, you haven't even explored. It could be something where, two service members are competitive and alpha and, come to blows, and they're in a training environment where they're learning, different techniques, and one of them snaps a bone or, snaps a ligament, tears a ligament. Facial reconstruction I've seen related to, one of those sparring type accidents.
Wow.
There are other ones where, you've got a Humvee that rolled, you've got somebody that's picking up something really heavy that falls into them. One of the ones that I've seen, a pallet fell on the individual's foot, right? Somebody else dropped a pallet on their foot.
Interesting.
Yeah, so it's when you think about it, you really, we see the IED injuries, we see the shrapnel wounds, individuals that were exposed to RPG, mortar fire, individuals that have taken rounds, and those can be on duty or off duty, right? We've got some that were injured in a shooting where they're just, going about their daily their daily life, but in more of a civilian capacity, right? They're not on base or anything, and they're injured in a shooting. That would be covered under TSGLI, as long as you met, obviously, the standards for the qualifying loss.
Absolutely. 2 quick things before we hit a break here. 104.5 WOKV, Jacksonville's News and Talk, protecting military families with Chris Brochu. You said a physical force has to cause the injury, correct?
Correct.
And everything you've been describing, I'm like, okay, that makes sense. Is there, what is not, if you can quickly, if not, we can save it to the other segment, but what's not a physical force?
It's a great question. This is where, and again, this is where a lot of the argument comes in, right? Because you rarely have this perfect scenario, and this is where hiring a lawyer can help, is that you've got to argue, and a lot of times there are cases. And one of the cases that comes to mind, I can't recall the specific facts verbatim, but it was something where the service member had, I can't remember what they were doing, but they walked by and broke their hip on, I don't know if it was their center island in their house or what caused them to, but I think in that particular scenario, because there was no external force, the person's
doing of something,
right? Their body gave way. That when they ended up, so when you file an appeal and you exhaust your TSGLI appeals, you have the right to file a lawsuit at the district court level in federal court in wherever you're based. So wherever you're a resident. So if you're in Florida here in Jacksonville, you'd file it Middle District of Florida, Jacksonville division. But they said that there was no external force because it was his own. I believe the facts were it was his own body that gave way. And there are exclusions to TSGLI as well. So before we forget about that, much like all injury and accidental death and dismemberment insurance, there are exclusions. So self-inflicted injuries wouldn't be covered. Any sort of mental or physical infirmity, right? So a heart attack, stroke, that wasn't caused by by something that was if you got into a severe car accident and had a heart attack and you were in the hospital for 15 days, that's still 15-day inpatient, right? It's not, you didn't have a heart attack, that's not why you're in, it's still related to the But those are the things that we get into the nitty-gritty about and really have to figure out. But if your family, if anyone in your family or your friend served October 7th, 01 to present day, either active, any branch, NOAA, Public Health Services, and Coast Guard, and they were injured on duty or off duty, active duty, National Guard, reservists, one-day muster duty, certainly something you should explore. You may be entitled to $100,000 if you have a TSGLI claim.
Absolutely.
Up to $100,000.
It's a lot of money. Real quick, we got about 2 minutes before we hit our first break of the day, but you've mentioned that date a couple times. I know we've talked about it in another episode, but if you haven't heard Chris's explanation for that, why is the date that's set that you can go back to, why is it that date in 2001?
I believe that it's because that was the first day that we had boots on the ground in Afghanistan. So after 9/11, I believe October 7th, 01 is when we made a formal declaration of war and had boots on the ground and had service members deploying and things like that. So yeah, you can go back all the way until the first day that I guess you could say war started, and then you can make a claim if you do have it. So that's why that date is important. And if you obviously served in either of those or since that date up until that date, and you have an injury of some sort that maybe didn't get sorted out, that's why they should contact you. case@brochulaw.com, or you can give them a call, 904-201-1771. We got to hit our first break of the day. We got more to do, though, more injuries to talk about, more about this topic, TSGLI. We will dive into that on the other side of the break. This is Protecting Military Families with Chris Brochu on 104.5 WOKV, Jacksonville's News and Talk. We'll be right back. Welcome back. Sunday morning, Protecting Military Families with Chris Brochu, the owner of Brochu Law, on 104.5 WOKV, Jacksonville's News and Talk. Talked a lot in the first segment about TSGLI. We will continue to do that. We'll talk about some of the losses and traumatic events that would qualify for you for that if you are a former service member or still in and potentially have a claim that Chris can help you out with. And always, if you need his help, he gives you the second opinion by Brochu Law. He will look into pretty much anything you might need a second opinion on, and unless he has to actually go into a case or something, it's free, right, Chris? Yeah, as long as you have a question about your military benefits and you get a free consultation to discuss, figure out if you're leaving benefits on the table or if you have a legal claim to anything else. And the only way that there's a fee is if we end up finding something and we decide to work together. We'd enter into a fee agreement, no fee unless we win. And we don't charge military families up front for any of our cases. So basically, no fee unless we win, and we advance all costs. So
you could say risk-free.
I wouldn't say risk-free, just because, the risk is you could lose, right? I mean, these aren't one size fits all. I mean, there are unique parts of every case, but what I will say is that your money is not at risk in terms of your own, right? You may have insurance proceeds or benefits that you may have available that you may not get, but your own money coming from your own pocket, we're not going to ask you to advance that. But if for whatever reason there was a claim or a case where we were unsuccessful, you're just out your time. You wouldn't have to reimburse us for our costs or fees.
Yeah, that's what I was getting at. I put you in a bad spot. I know I did. Honest mistake.
Oh, you're good.
All
good.
Move on. I just
good.
want people to understand what they're getting into.
Yeah,
you know what I mean?
No, it's a good question.
Anyway, if you need his help, case@brochulaw.com, BROCHU law, LAW.com, or you can give him a call, 904-201-1771. If you missed any of the first segment, go back and listen, WOKV.com, or on Chris's website. Justin with Nova Productions hooking us up with a video version of the show. So if you want to see me and Chris sitting here talking to each other, go check that out on his website, brochulaw.com. Chris, we're back in TSGLI. A lot to do with it, but we want to start this second segment at this point in a situation where we talked about the date that everything is qualified to that point in 2001. Do you have situations where you have service members that maybe served before and then continued on after, maybe straddling the date for lack of a better term? Do you have that situation come up, and how does that work if you have someone that served in, 99 to something or you get the idea. How does that work?
A lot of military families would fall into that category of service, right? They have someone in their family that served from, the early mid late 90s through, the early mid late 2000, around 06, 08, 2010. And the easiest way to think about it is, did the traumatic event occur on October 7th, 2001? And I actually have seen a lot of these. So it's unfortunate because we can't go back to a date before October 7th, 01. But let's say, you were in a traumatic automobile accident or some similar type of accident on, name a date before, right? You're injured in a significant or traumatic event in 1999. That would, even if, within 2 years of that traumatic event, right? Let's say it was December of 99 and you have a traumatic injury that leads to a qualifying loss within 2 years, right? After the October 7th timeline, you still wouldn't qualify because the traumatic event would have had to have occurred on or after October 7th, 01. So that's the easiest way to think about it. It is an absolute bummer. I've seen several of these where the service member clearly was in a traumatic event, clearly had a traumatic injury, which led to a qualifying loss. But unfortunately, as the statute is presently written, there was nothing that my firm was able to do.
Yeah, that's definitely unfortunate when it comes to that. I don't really know, like, what happens in terms of that? Like, you just said it, like, if there's nothing your firm can do, I'm not, like, why is that? But not like, why can't you guys do anything? But, like, do you know, is there something or a statute or something, like, why is that? I get the date and going forward, but going backward, like, is there really nothing there that can protect you if you had a similar situation?
Benefits would be available under, VA disability compensation or something like that may be available. But as far as TSGLI goes, in this closed universe of TSGLI, we are able to argue the statute and the law, and Congress enacted the law for October 7th, 01.
Yeah.
So, and that's the unfortunate part about some of these claims, is that you have a group of service members or veterans who have all, served in combat or the Gulf Wars or Vietnam or Korea and have these same traumatic events, qualifying losses. But as far as TSGLI goes, it's only available to anyone that was injured in a traumatic event on or after October 7th, 01. And if your loved one has passed away, right? Let's say you are the spouse of a service member who was in a traumatic event, who suffered a traumatic injury which led to a qualifying loss, and your loved one is no longer with us, but you have, you have questions if they did qualify or you believe that they do. We're happy to assist with those types of claims as well, and we're more than happy to speak with you if there is something available.
Yeah, absolutely. And if you think there might be something available, case@brochulaw.com to get in contact with Chris. All right, Chris, you mentioned it there. You mentioned qualifying losses and you mentioned traumatic events. We're going to cover both of them here in the next 20 minutes or so. Wherever you want to start, traumatic events or qualifying losses.
Traumatic events is where we're going to start because the traumatic event leads to the qualifying loss.
Sure.
Under the statute, it's got to go from a traumatic event to a traumatic, causing a traumatic injury that is obviously one of the qualifying losses under the statute. So I think it's important to provide some examples to really start thinking about types of traumatic events that people could be involved in. So I've got a list when we do an intake and we screen military families, we've got a list and we kind of go through different traumatic events, different qualifying losses. Hopefully that may recall certain things. I know that a lot of these claims, if you asked me what I was doing 10 or 15 years ago, it would be difficult sometimes to be like, on this day or, at this time period, I had X happen. So a traumatic event, here's some on-duty examples: an IED explosion, mortar blast, fragmentation from a grenade or a bullet, injured by a falling object, injured from, somebody else, right? You've got somebody else that caused an injury before I mentioned the pallet on someone's foot, sudden blow to the head, right? You were involved in an accident where you were thrown out of a Humvee, you were thrown out of your bunk. Those are two examples that I've seen. Chemical weapons exposure.
Interesting.
So this is kind of interesting. Anybody that was exposed similar to that. Pyogenic infection, which is fairly interesting. Let's say you were in some sort of mission that most of the time the example would be you were in a place where maybe the government didn't recognize, or you were in a place that, you didn't have anything available to you. You were drinking any water that you could find. If you developed an infection based off of that, which led to, 15-day inpatient hospitalization, that would qualify. And then the training exercises are really interesting. See a ton of parachuting, because again, you're training so frequently, right? You're jumping out of planes. I mean, it is absolutely incredible. It's remarkable what our service members and their families, they're heroes. I mean, it's truly incredible what they go through. I mean, the jumps, the stories that you hear, it's remarkable. So, you're injured, your parachute's tangled, you have a landing that's, unintended, you hit your head or you break a bone or something that causes a surgery. That would be a training accident. You're going through an exercise where, again, you're going through an obstacle course, you're on a ruck march, you name it. I mean, it could be anything that you could imagine related to a training exercise. And then deployment accident as well. If you were in a helicopter crash, if you're in a plane crash, if you had something where an external force caused, physical bodily harm. Traumatic brain injury would also be included. We're going to get into that. Traumatic brain injury kind of is coupled with two qualifying losses. One is 15-day inpatient hospitalization. The other one's inability to perform activities of daily living. But that would be, a traumatic event that caused a TBI, traumatic brain injury, and then some of the off-duty accidents. Right, there was a story, I remember a case that I saw where I think it was a group of National Guard soldiers were eating at a Waffle House. Somebody came in and tried to stick up the joint.
Oh wow!
And I don't know if they intervened or what happened, but it was a case where one of the soldiers was shot through her foot. And again, that led to a surgery, which, she was unable to perform at least 2 activities of daily living for at least 30 days. So she, that was a case where it was argued to the district court level, but that was a case where they found in favor of the service member under ADL loss. And that's a pretty unique example, but that's one of them,
Absolutely. So a couple of things off of that. I wrote this down, and then you kind of just got into it with the off-duty kind of things that could happen, but this just popped in my head for an example that I think people can understand. Just anybody can understand, I guess, because car crashes happen often. So if you're off-duty, but at home with family or something, you do still serve, but not at the moment, and you just go get in a car accident on A1A, does that covered?
It is. And the other thing to remember too is, let's say you were in a severe accident and you've already worked with a personal injury attorney. And I get a lot of personal injury attorneys that will send clients like, hey, we just resolved this trucking accident case, this motorcycle case, this automobile accident case, and they'll say, is there anything available to the service member from on the military side or the military benefit side? And it's really quite interesting because so many service members may be leaving benefits on the table that they didn't realize are available to them. And to your point, car accidents would be covered, boating accidents, jet skis, ATVs, rock climbing, anything that you could imagine, falling on something that was a negligence of some other company, third-party criminal acts, right? I've got a case where one of my guys was shot in a drive-by shooting. He was off duty, but that would be something that's obviously a traumatic event. Frostbite, heat stroke, those would all be things. Our service members are pushing their bodies to the absolute limit. A lot of the training requires that. So a lot of these are very unique to service members. They're not the typical injuries that you see associated with some of the personal injury claims. They could be very, very unique to service members because of the situations they're in, right? I mean, to get heat stroke or frostbite, you've got to be in a pretty unique situation.
I'd say, yeah, absolutely. With that, you've mentioned this a couple times, so I just want to kind of clarify it. You've said multiple times 15-day hospitalization. What's the 15 is the day? That's the number that just you have to hit.
Right. 14.
Not enough.
Not going to cut it.
Really?
Nope.
Interesting. And then I think you mentioned something that there's a 30-day of something.
Right. 30-day for ADL loss.
Yeah.
Right. So you'd have to, again, 28 days, not going to cut it. You got to get to 30. You gotta require assistance. You can't use an assistant or an adaptive device, right? So crutches or a cane wouldn't be allowed. I think that there are some scenarios, right, where some of the injuries I see, you can prescribe a walker commode, but this person, they can't get out of bed, right? They're not. How are they going to use their walker to get down to their first floor, right? They're not going to.
It's not going to happen.
Right. And the likelihood of them taking, the walker from upstairs or downstairs, and most of the time the caretaker is is their spouse, right, or a parent or a child. This is where the common sense side of the statute starts to, wait a second. So you're telling me that just because somebody was provided crutches with, name and injury, right? They shattered their femur, they don't qualify, right? They needed help for 90 days, but they don't qualify because the doc said, hey, after 90 days, try these crutches out. I mean, I think it's wrong, but I've got to argue what the statute says, and that's what
you're going to do.
My job is. So
absolutely. And then the other part of this is, I know we talked about it last week, but if you didn't hear it, you said you're unable to perform 2 daily living activities. First off, what are the daily living activities? And let's just start there.
This is actually a great segue into traumatic injuries and qualifying losses. So basically, if you have one of the traumatic events that I described, or you have one that I didn't, and chances are pretty good, if you think about any of the most traumatic things that you've encountered in your life, it may not have been included in there. So if you're a service member and you didn't hear one of the traumatic events that that matters to you or that fits you, it doesn't mean you don't qualify. It just means that, I can't think of the example. Right. But ADL loss, to get that started, is kind of the catch-all, right? ADL loss is the service member that had a traumatic injury that doesn't fit squarely into one of the other categories. So, you may not have lost a limb, you may not be a paraplegic, you may not be in a coma, it may not have required you to stay in the hospital for 15 days, but it may have required assistance from your spouse for 60 days. So the federal statute recognizes 6 activities of daily living: bathing, dressing, toileting, transferring, continence, which incontinence, right? Inability to perform your own bladder functions, and eating. And I'm going to break down all of those briefly so that we can kind of talk through it. The thing to remember with all 3 of those, and before we get into each one, you need one of 3 types of required assistance. You either need physical hands-on assistance, right? Somebody's physically holding you up, bringing you to the toilet, taking you off, helping you put your pants on, washing your back. Verbal assistance, right? A lot of times with the TBI or more sensitive sensory loss cases, verbal assistance, right? The pulling a shirt over your head, that may cause vertigo, right? You may need help. Okay, yep, do this, do that. And then there's also standby assistance. So maybe the service member has an injury where, they require not only physical assistance to get into the tub, but you don't want them to fall down, right? It's not like you're putting them in the tub and then you're saying, all right, I'm going to go get breakfast. Call me when you're done. I mean, these are serious injuries here. So those 3 things: physical, verbal, standby assistance, required assistance. What we then look at is, okay, how long was the required assistance for? TSGL recognizes 4 categories for ADL loss: 30-day increments, 30 days, 60 days, 90 days, 120 days. Those 30-day increments are also important to know because they are reflective of how much compensation you can receive. So if you hit 30-day ADL loss, you are entitled to $25,000. If you hit 60, you're entitled to $50,000, 90, $75,000, 120 days of ADL loss, you'd be entitled to $100,000. Now, again, that's not me as your lawyer saying that. We've got a medical professional that's got to review your medical records, review your claim, and that determination's up to them. But that's the starting point. So just getting into it, bathing would be, getting in and out of the shower, in and out of the bathtub. assistance bathing 2 or more parts of your body. Toileting, same thing. Do you need help using the restroom, wiping, getting on and off the toilet, dressing? Do you need help getting your clothes? Do you need help putting your clothes on and off, right? You need help with taking your clothes on and off. And then there are specifics in the form that we submit, so we'll get into that. But for time purposes, those are kind of the major hitters. Transferring, right, in and out of a bed, on and off a couch. Those are the main ones. Eating would be not you can't make a meal or you need help doing the dishes, but somebody is physically helping you eat. Continence, same thing. Somebody is physically helping you with your bladder function. And I think we got all those, right?
Mm-hmm.
Okay. I was thinking, are we missing one? But I think we got all 6.
No, go ahead.
No, so I think that's about it.
So here's the unfortunate part about radio, Chris. We are out of time. And I know you had more to say. I know you did. Now, this is what we call in the business a tease, because next week I think you're going to keep continuing into some of this stuff with TSGLI, because it is fascinating and there is more you want people to know. So I think we'll have to talk a little bit more about that next week. But until then, this has been Protecting Military Families with Chris Brochu. If you missed any of the show, go back and listen, WOKV.com, or on Chris's website, brochulaw.com. If you need his help, case@brochulaw.com, BROCHU law.com, or give him a call at 904-201-1771. Check out the video version of the show on his website. Thanks to Justin at Nova Productions, and we'll talk to you next week.
Thanks, Casey.